Iku Iluna, please rise. Auhea oko ikoka aha, inahe kuliana imua okea, aha ho o kolo kolo ki eke hano hano, oka moku aina o Hawaii. E naoi mai, e malio mai, I lohe ia kaleo. Hear ye, hear ye, hear ye, all persons having any business before this Honorable Supreme Court, State of Hawaii, draw nigh. Give your attention and you shall be heard. E noho lau, please be seated.
Please call the case.
Case number SCWC-16-0000444. MAUI LANI Neighbors Incorporated, a Hawaii nonprofit corporation for State of Hawaii et al. Arguing for petitioner, plaintiff appellant MAUI LANI Neighbors Incorporated, Peter Martin. Arguing for respondents, defendants appellees State of Hawaii et al. Miranda C. Steed, Deputy Attorney General. Also appearing, Daniel A. Morris, Deputy Attorney General. Arguing for respondent, intervenor appellee Alexander and Baldwin LLC, Calvert G. Chipchase. Also appearing, Christopher T. Goodwin. Also appearing for respondent, County of Maui, Kristen Tarnstrom. Argument on the merits.
All right, good afternoon. Aloha, everyone. Our proceeding today is being broadcast live on our YouTube channel as well as on Olelo. I'd like to welcome our substitute justice, Judge Jeanette Castagnetti. Thank you, Judge Castagnetti, for joining us today. Counsel, are you ready to proceed? All right, just to confirm, we have 30 minutes for each side. Mr. Martin, we're going to give you a warning after 25 minutes, so you know that you're getting to your rebuttal time. Ms. Steed, 15 minutes. Mr. Chipchase, 15 minutes, and we'll give each of you a warning light when you have 5 minutes to go in that 15-minute period. Please proceed, Mr. Martin.
Good afternoon, Chief Justice Rechtenwald and members of the court. Article 11, Section 9 created a new right to enforce environmental laws. Its intent was to eliminate the barriers that often frustrate resolution of a claim on its merits. The ICA now imposes a major barrier to this important right. It shuts the courthouse doors. The ICA gravely erred in 3 ways. First, it undermined Loop in the plain language of Article 11. Second, it misread the statutes, HRS chapters 91 and 632. Third, it misapplied the exhaustion doctrine. Turning now to the first point. In Loop, this court recognized that Article 11 established a self-executing private right of action. Nothing in its plain language limits such an action where issues could have been presented to an agency. In fact, the delegates understood that it allows an individual to directly sue a violator in court. Chapter 632 does not limit this right. Maui Lani's claims are based on the environmental laws in Chapter 46, zoning, and Chapter 343, HEPA. These claims stand on their own. They are self-executing and they do not need to rely on another statute to state a cause of action or for a court to provide relief. Moving now to the second point.
Oh, could I just stop you on that point? But the ICA suggested or noted that in Loop we said that right of action is subject to reasonable limitations or reasonable requirements or restrictions. Why is not the 632-1 requirement of recognizing if there's a special cause of action for a particular claim that cause of action should be used applicable here?
2 reasons. First, Chapter 632 is a separate statute. Our environmental claims are under Chapter 46 and Chapter 343. They stand on their own. They're self-executing. We could have brought our cause of action on those 2 statutes alone, along with Article 11. The second one is the plain language of Chapter 632 states that declaratory relief must be provided where the essentials for such relief are there. That's another reason why Chapter 632 cannot be a limitation.
Also, I was just curious, you know, for the sake of argument, if this matter ends up going back and further litigation results in invalidating the special use permit, what do you see as the realistic possible remedies?
Maui Lani,
As I understand, the sports park is completely built out. Is that correct?
yes. Yes, the sports park is completed, that's correct. Maui Lani received a procedural injury, and on remand, we would ask that to the extent the sports park is still in violation of zoning, we would seek it to become in compliance with that. And at those hearings, including before the county council, we would seek conditions of zoning, mitigation, perhaps to noise, light, traffic, hours of operation, and use of the retention basin.
It would be along those lines?
Yes, along those lines.
Thank you.
Moving back to my argument, the ICA misread chapters 91 and 632. It ignored the plain language in these statutes. The plain language of 91 makes clear that an administrative appeal is not the only way to challenge an agency's actions. There are other means of review. Here, Maui Lani's claims are other means of review and are thus preserved under chapter 91. And as I mentioned, the plain language of chapter 632 also provides for declaratory relief anytime the essentials are present. This statute must be read broadly with a view of making the courts open to the people. Case law also recognizes that a plaintiff may assert both a 91 action and an original action. For instance, in Citizens for Protection of North Kahala, this court allowed an original action after a 91 appeal was denied. Although both actions had the similar effect of challenging a permit, the original action went further to challenge the validity of an ordinance and the applicability of HEPA, just like this case. Also, the
Can I ask,
court,
what limits would there be on enforcing chapter 46 under your view of the law? Is there, I know the ICA rejected the notion that there could be an exhaustion requirement. Do you agree with that rejection? And what if any limits might apply? Time limits? How far out could the action have been brought?
Article 11 is defined by environmental quality laws. And in those environmental quality laws, there are reasonable limitations. For instance, our 343 claim has a statute of limitations in it, a very short one. But it's up to the legislature to create those reasonable limitations.
What about in chapter 46? Is there a limitation there?
Chapter 46, there is a standing limitation. It says you have to be a directly affected landowner to bring this action. So there again is an example of the legislature making a limitation.
You know, if before the zoning, somebody knows about the proceedings, has the opportunity to participate, chooses not to, the agency makes a call here with respect to a permit, there's no appeal. You know, I think what the other side is saying here is, you know, to allow a 46 challenge, you know, you haven't, it's essentially a collateral challenge to a permit with an original action. And I'm just wondering if, you know, challenging collaterally permit matters doesn't really just feed into chaos and uncertainty. I mean, once the ship has sailed, aren't those types of challenges premised on 46.4 gone?
The answer is no for two reasons. First, as a practical matter, when there's a development going up next door, you have to act immediately. In our case, we immediately went to court a few months after the permit was issued and sought for an injunction. There is not that argument is speculation. There's been cases for 50 years where no one's challenging something 20 years later. The second reason is because in our case, we're alleging violations of the law.
But if we adopt, I mean, if we adopted your proposition on the 46, the zoning matter, I mean, it's not just your person who sought an injunction, perhaps semi-simultaneously. I mean, we would be making case law that essentially opens up the whole zoning permit finality aspects to it into, as the Chief Justice, I think, alluded to, some sort of an indeterminate time frame. Why wouldn't that just or cause this just, like I said, chaos?
It would not cause chaos, and I'll tell you why. The legislature, when they enacted 46-4, they saw that a private right of action was a necessary complement to government enforcement. When a county's not doing its job, when it's abandoning its duty, a private right of action becomes necessary. In this case, the county was not doing its job. It was not enforcing zoning. The planning director represented to the public that there would be a change in zoning before the sports park was built. Later, it approved as complete a special use permit application. That's an example where a private right of action is necessary. The legislature, when they enacted 46-4 and gave a private right of action, wanted to make sure that zoning and development is always within the framework of a general.
Counselor, are you saying that anybody that moves into the neighborhood has a private right of action to challenge the permit?
46-4 states that if you're a directly affected landowner,
Right, so
You
somebody
have-
moves nearby that sports park, they can file a private right of action? Anybody? I mean, where does it end with the finality?
I think as a practical matter, the sports park is built. Our client immediately sought court relief. It is not a collateral action 20 years down the road.
Right, but the ruling today would have ramifications going forward. So my question is, anyone that moves into that neighborhood and is affected, can they then pursue a private cause of action in court?
This issue hasn't been briefed, but I would say there's a standing concern there. There's also a laches concern. There are doctrines that allow that directly address untimely suits. Laches is one, statutes of limitations is one. In Hawaii, there's a general statute of limitation of 6 years. Well, no one's gonna be bringing an action after 6 years. It's barred under the general statute.
Okay, so you're saying there will be some restrictions that would apply?
Yes.
If you always have a 46A direct action, I mean, doesn't that make 46-4B superfluous?
No, 46-4B allows an action, a zoning order to be challenged in circuit court under the Hawaii Civil Rules of Procedure. It doesn't state that it has to be under 91 or under the as an administrative appeal. So 46-4B is consistent with the private right of action in 46-4A.
The private right of action, is it, or should it extend to suits against the government, or is it suits against other third parties? Which is, I think, I'm probably gonna mispronounce the name, PASVEC, or the case from the ICA from 2012, which Chief Judge Nakamura held. There could be a private right of action for folks who are trying to stop vacation rentals in their neighborhood. The allegation that those rentals were unpermitted or improper. That's one type of private right of action. Do you believe that the legislature in the statute intended for a private right of action against the agency, the permitting agency?
Absolutely. 46-4 creates a private right of action to enforce zoning where an agency is violating the law, where an agency is ultra virus. That's not consistent with the general plan. That's what the statute is trying to ensure. This court has allowed a number of original actions to challenge a number of things that are not consistent with the general plan, including zoning by initiative, validly enacted ordinances in the Lum Yip Key case and Dalton cases, those two cases. The Kaiser case is the one where the zoning by initiative is challenged. All those things aren't necessarily enforcing an ordinance, but they are ensuring that zoning and development is within the framework of a general plan.
So your position is that the statute contemplates an entire administrative proceeding with a right of appeal, and at the same time contemplates an action against the agency challenging and raising the very same issues that could be or were raised in the administrative process?
Here, we do not have the exact same issues as in the citizens case. We are also challenging the validity of the special use ordinance. We are challenging the applicability of HEPA, and we're challenging the ultra virus acts of an agency that we allege did not have any authority to do what it did.
So, let's put aside for a moment the validity of the ordinance. So that would be a straight up challenge saying the ordinance is vague and ambiguous. Count 3, I think, correct?
Correct.
Okay. And HEPA, there is a statute which actually authorizes the circuit court to consider challenges to the validity of the EIS, correct?
Correct.
Okay. Now, ultra virus is kind of going back to, all chapter 46. Was it properly applied? Is this the right interpretation of whether it's a park use or open, playing field or whatever? Isn't that just, so certainly some of your claims are not strictly under chapter 46, but an awful lot of them are. I mean, all of count 1 pretty much seem to be issues that could be raised in the chapter 40, in the administrative proceeding.
It is established law that a special use can't be used for something that's not in the statute. There's an argument about the playing fields. We're saying as an issue of statutory interpretation, a court can address that as a matter of law. What does this statute mean? The defendants are saying it means one thing, we're saying it means another thing. But there are other uses that were approved to the sports park that are nowhere to be found in the special use ordinance, including a retention basin for a neighboring development. That is not a special use for agricultural districts. The Planning Commission had no authority to approve it without a change in zoning and going through the other procedural hurdles that would be needed to do that.
Part of your argument is that a supplemental EIS should have been done, and perhaps there was illegal segmentation. Is that part of the arguments
Yes,
that you put forward?
yes,
And the ICA seemed to be saying that you may be able to pursue the HEPA claims, but you can't use it to invalidate the permit. But at the same time, if there's HEPA violations, wouldn't that invalidate potentially invalidate the permit?
yes. There's
How
case
does,
law.
how does that make sense then?
There's case law where there's a HEPA violation and the agency's actions are void. And it would be like Kapo'o, that would be one of the cases, or
But the
Kahana
ICA is
Sunset.
saying you can't use that to overturn the permit. You may be able to pursue the HIPAA claims, but not use it to invalidate.
And the ICA.
Did you read it that way?
Yes, and the ICA erred when they remanded the HEPA claim, because they only remanded the HEPA claim to the extent it didn't challenge the permit. But essential to HEPA review is that environmental review must come before any agency action. You can't we made a HEPA challenge before this thing was built. That was ignored.
So if you prevail on that claim later, that could invalidate the permit.
Correct.
Thank you.
Okay, going back to the argument, I'm going to turn now to the third point. The ICA misapplied the exhaustion doctrine. Exhaustion only applies where a claim is originally cognizable by an agency alone. Here, Maui LANI claims are cognizable in court, and thus exhaustion, by definition, can have no application. Exhaustion also does not apply where there are no effective remedies. Here, the Planning Commission was powerless to adjudicate the scope of its own authority. For that reason, exhaustion should have not applied.
But your argument assumes there's a private right of action to sue the agency, correct? In other words, if we were to hold that the extent there's a private right of action, it's only against third parties or other folks in the community who might be violating the law, then there wouldn't be jurisdiction in the court, correct?
The 46-4 grants jurisdiction to enforce a zoning ordinance. And so if there's a private violator, the cause of action would be against a private violator. There could also be a cause of action against a public violator if it's needed to enforce a zoning ordinance.
But against the agency or the entity that's issuing the permit? Yeah, for sure. If there was another government agency that was somehow violating the law, there could be an action. Again, I'm referring to the ICA case from 2012. But does the statute in your view, the statute authorizes or empowers the circuit court to consider the very same issues that are considered through the administrative process in analyzing the permit? Because I looked at count one and that seemed like, you know, a lot of the same issues that one would expect to come up in the permitting process.
There's a distinction that needs to be made between an agency's violations of the law and an agency's discretionary acts. We're challenging the agency's violations of the law. In part, we're challenging the agency's discretionary acts, but an agency has no discretion to violate the law. And in that, and the circumstance of this case, yes, you can make it a collateral attack to make sure an agency is enforcing, is respecting the law.
Since you talked about the exhaustion, I mean, what do you make of the ICA's position that, you know, 632.1 just sort of codifies the exhaustion doctrine?
Two reasons why that can't be the case. The actual language of the statute says it needs to be serviceable to the people. That's 632-6. Where's the limitation there? Second, as I explained, our causes of action under Article 11 are self-executing. They're under Chapter 46 and 343. There's no need to rely on another statute to state a cause of action there or for our court to provide relief.
So the ICA's position that it was this codification, or they say akin to a codification, is just off, let's say.
Yes.
But in your count, I think it's count 5, the count that invokes Article 11. Let me find it here, sorry. Okay, it you know, pretty bare bones, first of all, right? Just says, okay, Article, Chapter 46 and Chapter 343, and we're bringing these claims under Article 11, Section 9, right? There's no explanation of which claims, which theories, why. I heard you allude to a moment ago, violations of law versus discretionary decisions. And the relief you seek is declaratory, injunctive, and other relief. So you say you're seeking declaratory relief, but because you didn't say 632.1, it's not a DEC action?
LANI is asserting that it's also entitled to declaratory relief under 632. All I'm saying is that's not needed to state an Article 11 claim. A court has original jurisdiction under the DEC statute to address all these issues. It's clear from the plain language of the statute, it's clear from the case law, and it's clear from the legislative history of that statute.
Very well.
You know, if you had intervened at that time before the Planning Commission, what remedy would you have wanted that they could not have provided?
The Planning Commission didn't have the jurisdiction to address HEPA, the scope of its authority. But even if it did, the key issue here is that the exclusive means to challenge it? No, there are statutes that provide for original jurisdiction in a court.
Could they have evaluated the environmental assessment in conjunction with the approval process of the permit?
They could have addressed it, even if they didn't have jurisdiction, and it could have been brought up in a 91 appeal. But the key issue here is that the exclusive means to challenge an agency's actions? Article 11 does not have that in its language.
That was going to be my next question, is whether or not they have exclusive jurisdiction over HEPA claims.
The court has original jurisdiction over HEPA under 343. So again, bringing up a HEPA claim at the Planning Commission, even if they could address it, is that the exclusive way you can make a HEPA claim? No.
Anything else? So I heard you say claims that it's beyond their jurisdiction. Is that right? I thought I heard you say Justice Devon said, give us examples of what relief you wouldn't be able to get from the planning commission had your clients intervened and ultimately appealed. One was HRS 343 regarding the HEPA claim, and the other I thought I heard was exceeding their authority.
Yes, and in count one, we allege that the planning commission exceeded its authority in a number of ways. It's not the planning commission's role to decide the scope of its authority.
Why wouldn't you have been able to raise that as an intervener on appeal, in a 91 appeal?
You could have raised that in an appeal, that's correct, but the key issue here is that the exclusive means for court review? It is not because of the Article 11, Chapter 46, Chapter 343, and also the declaratory relief statute.
But you could have made that argument before the commission that they were exceeding the scope of their authority if you had participated.
Yes, those arguments could have been made, but again, when we have original jurisdiction in statutes, a court has original jurisdiction there. Exhaustion can't apply where a court also has jurisdiction and an agency has jurisdiction. Exhaustion by definition only applies where a claim can be originally cognizable by an agency alone.
You're saying the commission did not have that exclusive jurisdiction?
No, it did not.
Because of Article 11, Section 9?
Because of Article 11, Section 9, as defined by the environmental quality laws that we cite, and also because of Chapter 632, that has to have a broad application and it must make the court serviceable to the people.
So you're at 25 minutes. Do you want anything further? You can continue with your argument now, or if you want to reserve.
I'll save my time for rebuttal. Thank you.
All right, very well, Mr. Martin. Thank you very much. Ms. Steed, please proceed.
Good afternoon, Mr. Chief Justice, Associate Justices, Judge Castanetti. May it please the Court, Deputy Attorney General Miranda Steed on behalf of the state. Process. It must be fair, and it can't be fair if it's not clear. Everyone must play by the same rules. And first, everyone must have certainty as to what those rules are. The ICA's thorough and well-reasoned opinion rejects appellant's claim that it need not participate in a clearly defined administrative process, one that provides notice, opportunity to be heard, opportunity to be further heard in a contested case hearing, and one that is subject to judicial review. This dispute is over the already constructed sports complex in Central Maui. The sports complex is a recreational and sports facility park with amenities like softball, t-ball, and flag football fields. Its purpose is to provide Central Maui residents with sports and recreational facilities. Now, appellant did not exist when the Planning Commission rendered its decision and issued DLNR, a special use permit. However, approximately a month and a half before the Planning Commission's hearing over the permit, appellant's future members received notice of the hearing, directions on how to intervene, and the information about the permit application. Many of those future members appeared and testified at the hearing, but none of them attempted to intervene. Instead, those future members formed appellant MLN months later and filed suit almost 6 months after the Planning Commission meeting.
Excuse me, MAUI LANI seems to be arguing that the commission didn't have exclusive jurisdiction over HEPA-based claims. What's your response to that? And I think they're using that to say they can pursue it now. How do you rebut that?
Appellant MLN can pursue their HEPA claim in the circuit court. That's what the ICA held.
I'm sorry?
The appellant can pursue their claim in
But
circuit
not to
court.
invalidate the permit.
So this goes to what HEPA actually is. The actual effect of a determination that plaintiffs are successful on their HEPA claim would render the permit valid, but not because it's attacking or revisiting the actual decision of the Planning Commission. A HEPA challenge is looking at the sufficiency of the environmental documents that are prepared prior to actually going and requesting something like a permit. So when someone brings a HEPA challenge, what they're actually challenging is that there wasn't enough environmental due diligence that the decision maker could actually review.
So are you in agreement that they can pursue the HIPAA claim to try and invalidate the permit at this stage?
The state is in agreement that they absolutely can pursue a HEPA claim, the result of which would, if they are successful, would be invalidation. Although
Certainly the potential for that.
there is absolutely the potential, although again, I would be clear that the purpose of HEPA is due diligence and environmental review, not to invalidate decisions that have been made.
And there is case law indicating that there are potential other remedies, including a further review and studies regarding mitigation.
Yes, that's correct. HEPA provides a number of remedies because again, the purpose is to make sure that there is due diligence before decisions are made. And actually, I'd like to address one of appellant's points that by the time they went to the Planning Commission, they couldn't have raised HEPA to the Planning Commission. If appellants did not believe that the HEPA process was sufficient, they could have challenged at the time of acceptance. And there's multiple HEPA documents here. One was accepted by the LUC, one was accepted by the BLNR. Any of these could have been challenged well before the permit application even made its way to the Planning Commission, had appellants been concerned that the process itself was insufficient.
What's your response to the Article 11, Section 9 argument that they have a clear right to assert Chapter 46? Excuse me, let's start with Chapter 46. Claims based on Chapter 46, it's a self-executing right. And 632.1 is not applicable because they weren't bringing this under the declaratory judgment statute.
So self-executing means a constitutional right may be exercised absent implementing legislation. The provision is still subject to legislative limitations, and that's in its plain language. In Alalut, this court acknowledged that Article 11, Section 9 preserves the ability of the legislature to impose reasonable limitations on the exercise of that right. So if 632.1 or 9114 didn't exist, because both of those could potentially be avenues to bring this claim, then they would be able to bring it without asserting one of those claims. But because the legislature has acted, that is the limitation in place.
In what sense? Is it, again, in what sense is that the limitation? It's an exclusive remedy? Is it only applicable for suing third parties, or it's not applicable for suing the government? There's a process with an appeal in it. I think his argument would be that process envisions suits against the government, against the permitting agency. What's your response to that?
Okay, so I'd like to break that up into two responses. So first, I'll respond to just the private right of action that exists under Chapter 46 itself. That private right of action, the ICA correctly read in pari materia with the rest of 46.4. And what it determined was that 46.4 contemplates the actual establishment of zoning procedures in a county, which means that the county has the authority to establish how it's going to implement its zoning, including issuing things like special use permits. In doing that, the county also has the ability, and as we see here, lays out the process by which that permit may then be challenged pursuant to its own rules, which is generally in a form of participatory governance, as in here testifying and intervening in a contested case here. Now, what appellants conflate is that there is also a private right of action contemplated, but as I believe Mr. Chief Justice, your questions alluded to, that is against other parties. It doesn't make sense reading the statute as a whole that the county would have the ability to establish an entire process by which citizens can participate and have their rights heard, but then also allow citizens to turn around and sue the county after it's made its decision, particularly when they haven't even participated in the first place. Rather, the PAVSEC court got it right. 46.4 is an appropriate private right of action when there is a private violator, such as short-term rentals on the shoreline, and government has not enforced. That provision is a supplemental provision to ensure that enforcements do happen and puts the power into the hands of the citizens when government hasn't come through. Turning to Article 11, Section 9 and 46.4, this would need to be asserted in the actual contested case hearing because Article 11, Section 9, defined by Chapter 46, refers to rights asserted by the appellant. Now, in asserting those rights, what they are in effect saying is that this permit may affect a right that I hold. And that has to be decided by the actual decision maker because the decision maker has options at that point. It could determine that the rights presented aren't affected, approve the permit as applied. It could determine that there are rights implicated and that the permit as applied is going to impact those rights and therefore impose conditions to lessen the impact or to protect and make sure the rights aren't actually implicated. Or it could even just deny the petition based on the rights and privileges presented by the intervening party. To not participate through the 91 process when asserting an Article 11, Section 9 right under 46.4 deprives the agency of the ability to actually contemplate the rights and privileges asserted prior to making the decision. It instead...
Counsel, I'm sorry, I have a little bit, perhaps you can help me. I know we have held many times that Chapter 205 is a law relating to environmental quality. Have we held that zoning or Chapter 46, or are there other cases that have held that zoning laws are laws related to environmental quality?
I apologize, Your Honor. I'm actually not sure. What I can tell you is that the substantive rights asserted in this case haven't been challenged because the question comes down to purely one of procedural. So that question would, I think, be better answered had the appellant intervened and actually asserted that right. Then that would have been before the Planning Commission.
Because they are arguing that under Article 11, Section 9, they have it's self-executing and they can assert 46-4 claims directly through a 632 action, right?
Oh, so I think the issue is the conflation between the substantive and the procedural component of Article 11, Section 9. Because again, the substantive component, right, actually defines when you have the right implicated by statute, but the procedural component defines how that right is actually asserted. And so in this case, the argument put forward by appellees here is that there was an entire administrative review process in which that right could have been asserted. The difference is that if, for example, there was no ability to intervene in the process, it was, closed door or something like that, then it would be possible for the appellant to come through on a 632 action because yes, they have a right and of course they can assert that right.
Or else like under Kellberg, if notice was not provided.
Exactly. If there was some kind of deficiency that would render it futile, then no one's arguing today that they would be deprived of going to court. The issue here is just that there was a very clear process and no dispute that they were aware and could have participated in that process.
The ICA in analyzing the Article 11, Section 9 claims relied on the provision in 632.1 that talks about a specific process. Mr. Martin says this wasn't brought under that statute, so that process, that provision is inapplicable. What's your take on that argument?
So I would direct this court's attention to Hawaii Association of State Teachers v. Abercrombie, which was actually a challenge to Chapter 89 and the Hawaii Labor Review Board. But the issue in that case was whether or not the petitioner could challenge bringing a constitutional claim before the court, when actually what they were really challenging but not saying was a prohibited practice, which was covered by 89. And 89 had been specifically vested in the Hawaii Labor Review Board. So in that case, what this court held was that despite the lack of actually pleading 89, the question is what is the actual issue being pled, not how it's dressed up. So here, regardless of whether or not the appellant pleads 632.1, if they're claiming declaratory relief, 632.1 is the declaratory relief statute. They cannot evade a procedural limitation simply by wordsmithing it or omitting certain words or statutes.
Isn't 91.8 or 91.7 also a declaratory relief statute?
Yes, and that would apply to, so 91.8 is, 91.7 and 91.8 are both deck relief. I believe 91.8 is in court specifically to challenge the constitutionality of rules before the agency. And 91.7 is the deck relief statute to go to the agency and ask it for a declaratory relief under its own rules. And so here, if I very briefly address count 3, because I think it's raised by that question, when they challenge the ordinance and call it unconstitutional, again, this comes back to not just how they phrase the count, but what they're actually asking for. And what they're really looking at is to invalidate the permit. They're claiming, well, we don't think that the way you put out playing field or the amenities that go with playing field count, and therefore this is a zoning violation. But that's really a discretionary decision for the agency itself to make. Now, that's reviewable by the court, and the court could always review it and determine the agency was wrong in its application. But ultimately, that question still comes first before the agency to apply the criteria laid out for a special use permit to the actual application for that permit.
About a minute left, a little more. If you want anything else you want to bring to our attention?
Unless there's further questions, I can briefly conclude.
Anything further?
Okay.
All right, thank you, Ms. Steed, appreciate it.
All right, if I could just give a very brief conclusion.
Oh, I'm sorry, that's what I was inviting you to do, so go
No
ahead and give your
problem.
conclusion.
The Planning Commission operates as a participatory government. Nothing precluded appellant from taking part. It chose abstention, but this state has recognized that our best policies are born of citizen participation. Choosing to sit on the bench rather than playing ball does not entitle one to challenge later decisions off the field. The state respectfully requests that this court affirm the ICA's decision. Thank you.
Very well, thank you for your argument. Mr. Chip Chase.
Good afternoon, Cal Chip Chase for respondent Alexander and Baldwin. The only doors that closed are the doors that plaintiffs closed themselves. Alla Loop does not open them. In Alla Loop, there was no process. There was no procedural mechanism to challenge the failure to require a special use permit. Declaratory relief under 632.1 as the procedural vehicle for Article 11, Section 9 was therefore available. Here, there was a procedural vehicle, participation before the agency proceeding, of which plaintiffs' members had notice of where, what, when, why, how, not only of the hearing, but how to participate in it as either members of the public or as parties to it. They intentionally skipped that process. Some testified, some were present but didn't testify. None of them intervened as parties. None of them appealed and maintained appeal even after they received the decision. Having entirely skipped the administrative review process and brought a collateral challenge on the day that construction of the park was set to begin, plaintiff failed to exhaust its administrative remedies. That is not saved by 46.4. As plaintiff conceded before this court, and as this court recognized in Alla Loop, the right to bring an action under Article 11, Section 9 is limited by the statutory vehicle through which that action is brought. In Alla Loop, the court acknowledged that the limitations in 3437 would serve as a limitation on the right to bring an Article 11 claim through Chapter 343. To the same extent, the limitation in 632.1 is a limitation on the right to bring that claim through 632.1. Article 11, Section 9 doesn't give a plaintiff broader procedural rights than the statute through which they're acting. With respect to 46.4, Justice McKenna asked whether it has ever been recognized as a statute relating to environmental quality. I don't believe that it has. And I don't believe that this court needs to decide that issue in this case for two reasons. First, 46.4 by its terms under A, relates to enforcement. This action, the gravamen of the complaint, as plaintiffs conceded on appeal before the ICA, is a challenge to the issuance of the permit. It's not to enforce zoning ordinances. It's to challenge the result reached by the Maui Planning Commission, which brings me to my second reason. 46.4 is subject to the exhaustion doctrine. If there's an opportunity to vet the issues before the agency, it has exclusive jurisdiction to hear them, and the agency here does have exclusive jurisdiction over whether to issue the permit.
But it doesn't have exclusive jurisdiction over Article 11 claims, does it? Those are property rights, substantive rights.
It depends
So
on,
even though they didn't participate in the hearing, how does that get wiped out?
it depends on the statute through which they invoke or affect their Article 11, Section 9 rights. In MECO, for example, this court recognized that Article 11, as exercised through the substantive statute that was at issue in that case, gave plaintiffs a right under due process to intervene and have an administrative hearing. MECO didn't say that in addition to that administrative hearing, addressing the substantive statute that recognized or through which your Article 11 rights are recognized, you can then later bring the 632.1 action vindicating the same rights that you could have vindicated through the
Do
proceeding.
you agree that exhaustion is based on the initial premise that that agency has sole jurisdiction, original jurisdiction, however you want to describe it? That's what triggers exhaustion.
That is correct.
All right.
And so you look at the substantive issues that are raised, not the procedural dress. The
Where is
substantive,
there exclusive jurisdiction in this statutory scheme?
I'm sorry,
Where is there exclusive jurisdiction given to the agency in this statutory scheme?
the exclusive jurisdiction begins with 46.4 delegating to the counties the zoning power. From there, you turn to the county code, specifically 19.510.70 and 19.510.050, where it sets forth the procedures for the issuance of a special use permit for county-zoned agricultural land. This land is state urban district. It's county agricultural. And so the proceeding was entirely a county proceeding through the ordinances on a county special use permit, which the county calls a CUP. Only the Planning Commission had authority to issue that CUP. And so then you look at the injuries that they complain of. If you look at count 1, every single one of the issues that they raise in their count 1 under 46.4 are issues that the Planning Commission considers under subpart 070. If you look at count 2, it's entirely duplicative of count 1, simply asking for declaratory relief. If you look at count 3, it challenges the special, one portion of the special use ordinance as unconstitutionally vague. Section 91.14 expressly empowers a court to consider constitutional issues on appeal from an agency proceeding. And this court, in multiple cases, has considered constitutional issues raised on appeal from an agency proceeding, including that the ordinance was void for vagueness.
But can't that claim of vagueness in the ordinance be divorced from or considered independent of the CUP process? So could not that claim proceed in court?
Not as pled by plaintiffs. If they sought purely prospective relief, meaning they looked forward in time and said, going forward, you cannot approve a special use permit under this section of the special use permit ordinance, then I would agree that could move forward. But what they sought through that count is to invalidate this permit. So they sought through that count retroactive relief in validating the permit, the same relief they could have and should have sought through the 91 process. The 91 process exists, as this court has recognized in MECO and many other cases, for very important reasons. It is the nearest point to the decision. It is more flexible and less formal than a court, less costly for applicants and participants in it. It serves judicial economy as well, because it allows the development of a record and a decision by the group tasked with or with expertise in that particular subject area. It also serves the important goals of finality, predictability, and fairness. All contested cases are subject to due process, so ensured a fair hearing that can be reviewed by the court. They allow the agency to hear all the issues before it and to fashion appropriate remedies, such as conditions on the permit, that may mitigate the harms complained of.
Could I ask you to jump to the 343 claim, the HEPA claim?
Yeah, sure.
What's your response to the suggestion that although the ICA said, although the HEPA claim can be considered by the circuit court, it can't invalidate the permit? Why couldn't it invalidate the permit as appropriate relief? Our law seems to say that if the environmental review has been done improperly, a subsequent permit is invalid.
Quite correct, Your Honor. And so I take the ICA statement in the context that it was given. The ICA allowed that claim to go forward. The comment that to the extent it doesn't seek to invalidate the permit, as I read it, is a statement that in the effect that it's not just a dressed up challenge to or appeal from the Planning Commission's decision to grant the permit, as so much of their complaint was. The ICA simply recognized that in the first instance, it should not be parsing counts 5 or count 6 to determine what are merely dressed up challenges to the CUP and what are other actions that may proceed in court. Instead, it should be the trial court to consider those things in the first instance and make the disposition in the first instance.
So you would agree that if the HEPA review by the court determines that the law wasn't appropriately followed, that for example, a supplemental EIS should have been completed but wasn't, that could invalidate the permit?
I agree that would be the effect. The effect would be invalidating the permit, not because the Planning Commission improperly issued it, didn't have the authority, implied the statute's wrong, didn't consider the scope of its authority, but because the underlying environmental review was invalid. That would void the subsequent permit as the effect, but not as the nature of the challenge. That's how I take the ICA's decision. That's how I read it. And that's the same with count 6, dealing with Article 11, Section 9. To the extent you mean something other than a mere appeal, your claim may go forward, and the trial court should make the determination in the first instance what the nature of that claim actually is. And that's consistent with UPW, where this court looked beyond the way the claim was pled to the substance of it.
Did anyone argue the Chief Justice's opinion last year in Academic Labor United versus the Board of Regents of the University of Hawaii?
I don't believe so, Justice.
That seemed to be a deck action, a 632 deck action, and I think we held that it should have been brought, there was a failure to exhaust administrative remedies, and a deck action was possible in HLRB. And I'm just wondering whether that is analogous to this situation.
I'm not familiar with the case, but I am familiar with Punohu. And Punohu recognized that if an administrative procedure under Section 9114 was available, a declaratory action under 632.1 does not lie because you failed to exhaust your administrative remedies under 9114. I'm also familiar with Kona Old, which recognized that you can't sandbag, skip out on the administrative process, and instead bring what would have been a direct action under 205A6. There's no basis for treating 46.4 any differently than the court treated 205A6 in Punohu in terms of the available remedy. In that case, the court ultimately dismissed the complaint, not remanded to the agency, not held the case in abeyance to pursue administrative remedies, but dismissed it because they had avoided or failed to follow their administrative remedies and the time to pursue them had expired. Because exhaustion applies in this case, plaintiffs argue in their petition, as they argued below, that exhaustion would have been futile. They make 3 points. The first is that the Planning Commission could not have considered their claims. As I said, between the Planning Commission and the courts, counts 1, 2, 3, 8, and 4 could have all been considered in the 9114 process. They argue that the county is failing to enforce conditions on a land use commission district boundary amendment under Chapter 205. But as this court held in LANI, the Land Use Commission has exclusive jurisdiction to determine whether a condition is violated. If it's violated, the county has enforcement proceedings. You have to go to the Land Use Commission first. Plaintiffs did. Their complaint was dismissed because they filed the wrong type of action. They failed to appeal it, and they failed to file the correct action under 151593 HAR before the Land Use Commission. Their last argument is that they didn't have notice. The record amply establishes notice of the proceeding. They complain they didn't have notice of the decision. One, that is not true, as the record establishes the individual members did receive the decision and they didn't appeal within 30 days after receipt. 9114 provides for an appeal period 30 days after service. They didn't take it. The second problem is that because they didn't participate in the administrative proceeding and weren't parties to it, they shouldn't have appealed under Chapter 91. This court in MECO has made entirely clear that to participate in appeal from a contested case means you have to follow the procedures available to you to intervene. They didn't do that, and so they weren't entitled to service, even though they ultimately got it. This is,
Oh, I'm so sorry.
no, please.
With regard to the Article 11, Section 9 claims, do you agree with the ICA's approach of applying 632.1? In other words, do you agree with Ms. Steed's arguments that we should characterize these as properly, although pled under that provision, they in effect are declaratory judgment action claims, and 632.1's proviso regarding more specific action should apply, or do you see another analysis?
I would say 2 points, if I may, Chief. The first is that I agree Article 11, Section 9 requires a procedural vehicle. As the court described in MECO, there must be some procedural mechanism or procedural route. In a la loop, the court recognized those as Chapter 343 and 632.1. In MECO, the court recognized that procedural route as Chapter 91. So there needs to be some mechanism through which it is litigated. I agree that if you are seeking declaratory relief, you are litigating whether you say it or not through 632.1, and that the limitation there applies.
Could you go back to a la loop? I'm sorry, your argument was that in a la loop, we said there had to be some procedural vehicle in place, but it wasn't the holding of a la loop that there was a direct action under the Constitution, which was self-executed, subject to limits. That was kind of the whole argument, that you needed something to enforce the right. And we said, no, you can enforce the right, but subject to limits.
If I misspoke, I apologize,
Yeah,
but I meant
perhaps I
in
didn't hear
MECO.
you. Oh, I'm sorry.
In MECO, the court recognized there must be a procedural route, was one phrase the court used. The other was a procedural mechanism. In MECO, the court referred to the a la loop case as using 632.1 as one of the procedural routes available. The court in a la loop also recognized that 343 would be another procedural route available, subject to the limitations period in 3437. In MECO, the court also recognized Chapter 91 as a procedural route to vindicate Article 11, Section 9, as expressed through a particular statute relating to environmental quality. The Article 11, Section, I see I'm out of time, Chief. May I
Finish
conclude
answering
briefly?
the question and then wrap up at that
Yeah,
point.
very good. The Article 11, Section 9 claims, as I began with, don't give parties a broader right than the statutes that authorize them. And so in 632.1, if it is subject to reasonable limitations or a specific form of remedy to be specific, then so is your Article 11, Section 9 right as expressed through that statute. If you pursue Article 11, Section 9 through another chapter that is subject to exhaustion, like 46.4 would be, assuming it was recognized as an environmental law, then it is subject to the exhaustion doctrine as well. I'd end where I began. The procedural door, the administrative door, was open to plaintiffs' members. They simply failed to walk through it. And by operation of Chapter 91, the door closed. What they argue for here is a backdoor that would completely eviscerate Chapter 91 and all of the benefits that it provides. If 46.4 is read as always providing an original cause of action to vindicate or challenge the approval of a permit, there is nothing left of Chapter 91, the process that Chapter 91 mandates. We go from a 30-day statute of limitations to a 6-year statute of limitations. We go from certainty, finality, clarity to chaos. Thank you.
All right, thank you, Mr. Chipchase. Mr. Martin, your rebuttal.
Yes, the defendants are arguing that 91 would be the only means of review. 91 is not the only means of review. It says that right in the statute. There are other means of review. The court should not establish a categorical exhaustion rule that prevents a party from seeking other relief. In this case, we are alleging that there are continuing violations of zoning. This is not something that's just challenge of an administrative process. This is a challenge to the administrative acts and their ongoing effect. There will be zoning violations until there's a change in zoning. Another thing that defendants brought up was the fairness. In this case, the notice that the individuals received who did not have an attorney at the time stated that they had time to intervene. It did not state that this was their exclusive remedy to vindicate any constitutional claim, any HEPA claim, any claim under the DEC Act statute. All it said is that you have to intervene by this date. Additionally, it is not in dispute in this case that there was defective notice. The notice of application was never sent. The circuit court found that that was a material factor, but still ruled that that should have been brought as an exhaustion argument, the defective notice argument. It would have been a material fact because it would have given the Maui LANI individuals who weren't represented at council at the time longer to organize, talk to one another, and retain counsel, and file the original action or participate as a party in the proceedings. Punohu, that was a case where there was a party who had a full and fair contested case hearing. They had the right to cross-examine, they had the right to discovery. In that case, they were saying, this court said, the preferred route is a 91 appeal, not another means of review. That's not the case here.
Can I ask you, what's your response to the argument regarding Article 11, Section 9? I think it's count 5 or 6, that in effect, it's a declaratory judgment action that we should look beyond the pleading to what the relief is or what the practical impact of that claim is, and accordingly, that 632-1 limit should apply.
That's incorrect. This cause of Maui LANI could have brought its claims under Article 11 in Chapter 46 alone. They could have alleged that their zoning violations, that the permit was ultra-virus, there was abuse of the system, there were continuing violations. There is no need to rely on another statute to make that claim. Chapter 632 also provides another form of jurisdiction to the court. We pled that as an alternative form of jurisdiction, not as the only form of jurisdiction. When it comes to Chapter 464, the plain language provides a private right of action. It's not the role of a court to circumvent the legislature. There's no ambiguity in the statute. There's a private right of action that complements the county's enforcement of zoning. In this case, there are zoning violations. Therefore, there's a private right of action to enforce zoning. One last point, the LANI case was brought up. In LANI, was involving the Chapter 205. However, all loops said there was a private right of action to enforce 205. Our claim that the Land Use Commission's decision and order were violated we should be able to bring that as a private right of action. Here, the county was not doing its job. Maui LANI asked the county to enforce the decision and order. They declined. When that was appealed, the Board of Variances and Appeals never set a hearing on it. That is why it's a cause of action here.
I'm sorry, could you repeat the last point? When it was appealed?
So in this case, we asked the planning director to enforce the land use decision and order. They said they did not have to. We appealed the planning director's decision to the Board of Variances and Appeals. They never set a hearing. That's brought up in our exhaustion argument as another reason why exhaustion applies in this case.
But that's not appealed in this case.
That's a separate agency appeal that was never heard. In conclusion, the ICA's opinion eliminates constitutional and statutory rights to access the courts anytime an agency issues a permit. It allows Chapter 91 to be used as a weapon to deny access to justice. This court should affirm the public's rights to seek redress when it is injured. Thank you.
All right, thank you very much, Mr. Martin, Ms. Steed, and Mr. Chip Chase. The court will take this matter under advisement.
E ku iluna, please rise. Ua ho'oku'u ia mai ne ke aha ho'okolokolo ki eke hanohano o ku moku an Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.